Thank you very much. And let me suggest that after spending 16 years as an appellate jurist on both an intermediate and a state's highest court, that I think there's no question that the higher a case travels up the judicial ladder, the greater there's a need for the assistance of an experienced appellate attorney to help in analyzing the issues and identifying the points that will best resonate with the particular state or federal court that that case is going to be heard by. To do this, I think it's essential, and appellate counsel is most experienced in doing this, is to identify a limited number of salient issues. Probably 3, if necessary, maybe 4, if you have a threshold jurisdictional deficiency that could result in the dismissal of an appeal. That tends to happen if there's a preservation barrier, and that arises, I think, most commonly in the criminal context. Next slide. The higher that a case travels up this ladder, the more the issues need to be fine-tuned and the policy ramifications considered. These can include issues such as how does the rule that is being proposed affect future cases? This is a major differentiation between what trial counsel considers and what an experienced appellate attorney is going to immediately focus on. Does it affect the efficiency of the court system? Are you proposing something that's going to be cumbersome for the trial courts? These types of bureaucratic issues also have to be considered. Does it serve the aims of fairness and equity? These are, of course, really basic principles that appellate judges are always aware of. They want to do the correct and proper thing. And if you look at what you're proposing and it's not going to create a level playing field in other cases, that's going to be a problem. Does it impose unreasonable costs on one party? Is it a change that's more appropriately decided by the legislature, particularly if you have a case that's in a state's highest court? Those judges are going to be concerned with the separation of powers. This is something that appellate counsel realize that you can be asked, particularly if you have a case of statutory interpretation, a constitutional issue. They're going to be aware of the difference between the judicial system and the legislative process. And does it advance a beneficial goal in the state's jurisprudence? This can arise especially when there are evidentiary issues that are being questioned. There's new technologies that come to the fore that courts will look at. They were always trying to determine whether or not this is something that the state should adopt because there's been certain advances in society. So these are some of the factors that experienced appellate counsel know go far beyond the kinds of considerations that a trial attorney is going to look at, because the trial attorney, as Annette emphasized correctly, they are concerned with resolving the dispute between those parties. Once you begin to move to the intermediate and especially your state and federal appellate courts, the whole spectrum of the case broadens. And there's a lot more issues that have to be considered and formulated in a way that still keeps a clear structure of the case. For that reason, I sometimes suggest to people that when they have completed their appellate brief, to go back and look at the table of contents. Many appellate judges, myself included, when a brief was put on the desk, I would immediately go to the table of contents and look at what are the points that are being presented. If the judge cannot figure out what the case is about from looking at that table of contents, you have not done the proper job. And I think that most experienced appellate counsel will work on those point headings and create a table of contents that presents the outline of the story of the case and what the issues are. The judge should have a feeling, okay, I have some idea what this case is about as they begin to read the rest of the document.
Judge, can I ask you, when as an appellate judge, what did you think of briefs that did not include a table of authorities? Because sometimes they are not required in some courts. I include them as a matter of course, and I know a lot of people lament about the process of doing it, even though software now makes it incredibly easy to do. How did that affect your review of the case?
I think it should be a mandatory rule in all cases. It is, I think, unless you have the ability to do hyperlinks and you're sure that the judge in chambers is going to be able to use hyperlinks, it's foolish not to include a table of cases. But if you do, make sure that those citations are correct. I would get very frustrated when I was flipping to Westlaw and trying to find a case and I realized that the site that was in the brief was not correct, or the page references were not correct. It wastes the judge's time. They're going to lose the train of thought about your brief. So I think it is a very handy tool, but it's a tool that has to be prepared accurately. So it should be double and triple checked to be sure that those citations are actually what they are. And the same goes for record references. There's nothing more frustrating than looking for some factual assertion by a witness and you turn to the record page and the subject matter is not there. And that can very easily happen because numbers can get transposed. So I think experienced appellate counsel know that once they're done with the brief, all those record references should be checked by someone. And it need not be the appellate attorney, but someone who is able, if you've got a paralegal or an associate, someone who can actually go through and double check and make sure all those record references are accurately depicted. Next slide, please. So we're now at a point where you're trying to determine what your point should be. And these have to be, I think, presented in a very clear and concise fashion. I think when judges see 8 to 10 lines in a point heading, that can be very confusing. And many point headings are too specific to the case. I think that they have to have kind of a thematic tone to them so that the reader has an interest in the case and that it's presented in a fashion that gives the reader a sense of what direction this brief is going in. I don't think points that say something like summary judgment was improperly granted are particularly helpful. There should be a reason in there. You know, you're trying to create an impression in the judge's mind. This is a persuasive document. There's advocacy going on here. So you should always try to take advantage of all these different pieces of the brief in order to make sure that the reader is getting a message more than once about what some of these positions are. Next slide. Let's talk a bit about some of the what I call pitfalls that I see in many briefs, having looked at hundreds of briefs, both as a jurist and as in my tenure as Solicitor General for the state of New York. I think the biggest failing of many briefs is the use of very extensive string cites. I think some attorneys feel if they can put 5 or 6 cases in there, boy, that's going to show that there's a great deal of support for the point that they're making. The problem is that those lengthy string cites, especially if there's multiple parentheticals summarizing what those cases were about, the reader, there are studies that show that judges' eyes kind of skip over those string cites and will go to the end of that section. What I find particularly annoying is where there's an initial portion of a sentence and then a lengthy string cite, and I'm trying to look at the different lines to find out where is the end of the sentence. What's the full thought that's being presented here? I think if you have 2 or 3 really strong cases, they should be discussed in a narrative and an additional paragraph. I don't think 6 or 7 cites do the trick. You should concentrate. If you have federal or state's highest court precedent, you're going to want to be sure to talk about that. If there are similar cases that have been decided by the court that are helpful to your position, add those to the paragraph. I think a narrative makes far more impression on a judge than string cites.
The same thing. Question? I'm sorry.
Yes.
My question was, I know that some people have made a movement across the states. I know Brian Garner has tried to get judges and attorneys to put their citations in a footnote. It hasn't taken hold at all in New York, but I was curious what your opinion was about that.
Well, there are courts that like footnotes and there are courts that don't. There are judges that I have heard tell me that they don't read footnotes. They don't think they should be there. There are judges that believe the footnotes should be at the end of the brief rather than at the bottom of the page. I personally would rather read the footnote while I'm reading that page instead of having to flip back and forth, which can be very difficult when you're reading on a computer screen as opposed to the physical brief. I think you have to know the court. I think that's something that experienced appellate counsel will have familiarity with a particular court, and they will know they have attended programs, they've talked to the judges, they've submitted materials. They'll have a sense of whether that court appreciates footnotes or doesn't. The other thing to keep in mind is that many courts now have page limitations, and you have to look at the individual court rules to determine whether or not the number of words in the footnote is part of your total page limitation, which it generally is. So you have to decide, is this content in the footnote so important that I'm eliminating another sentence or two in my text? Next slide, please. Annette talked a little bit about the record. What I want to suggest, in addition to making sure that every factual contention that you present in your statement of facts and also in your argument points should definitely have a record cite. This gives the judge a sense of confidence that what you're saying is true. It adds to your credibility, but make sure that those record cites are accurate and that they actually represent the statement that you're presenting. Then I think what you do with those record cites, when you're preparing for oral argument, I think it's very important that you have what I'm going to call a cheat sheet of some of the major record cites that could relate to your oral arguments, the points that you're raising with the court. Sometimes judges will ask lawyers when they make a representation, well, where is that in the record? You really don't want to say, I'm not sure, I don't have it right here, but I'll give it to the clerk after the argument. You've just lost an opportunity to impress the judge with your knowledge of the case, and you also have lost a chance to be able to reinforce your point by perhaps summarizing what that record reference is. So I think it's very helpful at oral argument to have a cheat sheet of some of your major record references. It doesn't help to tabulate the record because you don't want to stand there and lose 10 or 15 seconds of your argument time flipping through your 2-inch record or 4-inch record while you're trying to look for something. So that's why I would recommend that you have a document on the podium that helps you immediately identify the record reference, and you just have to put some key words down so that you know what those are. Next slide, please. I'll make another point regarding oral argument. I think oftentimes attorneys are so intent on presenting a presentation that they have somewhat memorized that they lose the ability to actually listen to the judge's question. Experienced appellate attorneys recognize that frequently not only are they being asked an inquiry, but the judges, through the questioning, are conversing with themselves. This you see a great deal in the United States Supreme Court, but you also see it particularly in states' highest courts. I know that when I sat on the New York Court of Appeals, sometimes one of my colleagues would ask a question and I could tell that they had somehow confused one of the facts in the case, or they were, in my mind, misinterpreting some of the factual issues in the case. So I would ask what I call a friendly question to give the attorney a chance to clarify that point. And oftentimes I think it would be interpreted that I was asking something negative and they would go off on a tangent. It is important to listen very carefully to the questioning. Not all questions from the bench are hostile. The other thing is, if you are asked something that is breaking the flow of what you're trying to present, don't lose the opportunity to answer that judge's inquiry, because you don't know if that jurist is going to be the one writing your case. The worst thing you can do is to say, I'm going to get to that point later. Because when you only have 5, 10, or 15 minutes of argument, there's a good chance you will not get to that point later. And it's also very off-putting to the judge who asked the question. There's no advantage to that kind of response. The best thing you can do is to give as short an answer as possible as you think is necessary, and then go right back into the point that you felt that you hadn't been able to conclude. The same thing happens. Sometimes two judges will talk over each other, and you'll be answering one judge and another judge will interrupt and ask you something completely differently. You have to handle that diplomatically. If it's really very confusing to you, you can ask the chief judge, should I respond to the first or the second question? But basically I would probably jump to answer the second judge's question and then try to go back to the first judge. It all depends how hot the bench is and how quickly the questions are being thrown at you. Next slide. This slide reinforces what I just indicated about answering questions. You should always keep in mind what the time is that you have allotted for you and study the court rules. Appellate attorneys know that some courts allow the appellant to do a reply. Other courts restrict replies. There's only going to be 2 arguments. If you have the opportunity for a reply, it's important to really, I think, hone in on what the issues are that have been raised by your adversary, and to make sure that you dispel those within the short time frame, and to do it quickly, because you may be asked more questions and you won't have an opportunity to be able to answer whatever the strongest arguments were that your opponent presented. I think that attorneys should spend some time, at least 30 seconds, at the end of their argument clarifying what the remedy is that they're asking for in the case. This is particularly important in criminal cases, because often we might ask a defense attorney, well, if the court agrees with your position, are you asking for a particular count to be dismissed? Are you asking for the indictment to be invalidated? Are you looking for a new trial? The attorney should be prepared at oral argument to indicate what the specific remedy is, or if there's options, to explain what the options are to the court, but which is the preferred option. And you should have at least one case that supports that remedy. In the civil arena, sometimes this is not as big an issue, but you should clearly also indicate to the court what it is you would like them to order, so that the court is not trying to figure out what is preferable for your client if you are the successful party. Okay, I think that concludes my presentation. Thank you very much for the opportunity.
Thank you. Thank you for having me, and thank you to everyone attending. My topic for today is the differences between the trial court and the appellate court briefs. When you do a lot of appellate work, and I both handle appeals all the way through, but also advise others and review drafts of briefs from that perspective. And I see a lot of briefs, and it is amazing how quickly you can tell when someone essentially copies their trial court brief to submit to the appellate court. And the reason you can tell is that an appellate brief really should look different. Even if your primary legal arguments are the same, there are some differences between the briefs that an appellate counsel appreciates more so than somebody who may be very familiar with the case but doesn't do a lot of appellate work. So I'm going to mention some specific differences today for people to consider, with the caveat that, of course, we're not doing a deep dive into the subject in this presentation, and these examples are by no means exhaustive. First, the brief generally gets more focus on the appellate level than at the trial level, just by virtue of being the one thing you have control over. Of course, you submit the record and appeal, but the record is the record, and there's only so much you can do about it. Perhaps you might have some motion practice, like Annette mentioned, but at the end of the day, the record is the record. With oral argument, you can certainly prepare for oral argument, and you will have some people be better at it than others. But again, at the end of the day, you really don't have control over how exactly the argument will go. You don't know what questions the panel will ask. You don't know if they will have the exchange amongst themselves, and you don't know what opposing counsel will necessarily say. The brief is your only opportunity to present the case from your side on your terms, and obviously it's very important. Now, people might say, yes, but the brief is very important at the trial level too, and that's of course true. But the reality is, if you have a motion, like a motion for summary judgment, you generally spend a lot of time on supporting affidavits and making sure you're including all of the evidence that you need in admissible form and so forth. And you really are building a record. And then, of course, there are many appeals where there wasn't a similar brief below in the first place. When you appeal after a trial, you typically have a post-trial brief, hopefully to use as a reference. But that is rarely a document that can be easily converted to a good appellate brief. And, you know, it more marshals all of the evidence in the case and isn't focused on the specific, hopefully just 3 or so issues you're appealing. So starting from the beginning of the brief, the preliminary statement is something that people generally don't pay much attention to. It shouldn't be difficult. It should be very short. However, sometimes you have cases with very complex procedural histories, and you will see attorneys, for completeness, feel that they need to include all of the motions that were made or all of the judges that may have had the case over time. And it is really important that you only include relevant information, because otherwise you can start out with very distracting and frankly very boring. Even if it's a page and a half, it can, you know, it just doesn't get started with the substance of what your argument is. So as an example, we recently had a case that was litigated for over 12 years, and during that litigation it went to the appellate division on 6 or 7 different occasions. Well, in the preliminary statement of the last appeal, it's not necessary to recite the procedural history in every time it went up to the appellate division if it's not relevant. If it was on issues that are not relevant to the appeal that's here and now, you just need to explain why the case is before the court and how it got there. Another major difference is what issues you raise on appeal versus the trial court level. More times than not, at a trial court level, you raise all of the viable arguments you have. In part, again, is to preserve the record, but also because you may not know which arguments the court would want to adopt, and you go with the strongest ones first, but you usually include all of them in some fashion. On the appellate division, you generally have to be more selective and very carefully choose the arguments you think are the most compelling ones for that particular court. To the extent possible, you want to focus on legal issues rather than factual determinations, and you want to make it as approachable as possible to the extent you have complex facts. If you do not have appellate counsel handling the appeal, this is where it is important that you at least have someone else help you craft your main points. I found that even people who do a lot of appellate work, to the extent they were the ones that litigated the case for many years, especially through a trial, they have a harder time selecting issues for appeal. As an example, I'll use myself. We recently had a case. We had a 4-attorney trial team, and the case went on for many years, many motions, and a week-long trial. The issue was whether our client, the trustee, was imprudent in the investment decision in administering a trust. And obviously at trial there were many factual issues, and at the end of the day we lost the trial, so and of course in our view it was a wrong decision. Well, when it came to appeal, the record on appeal was over 15 volumes, and we had a team of 4 very bright attorneys, 2 of whom had a lot of appellate experience. But when it came time to draft the brief, each of us had certain issues that we felt extra strongly about, really as a result of having worked on the case for so long. And we felt extra strongly that the trial court got something wrong and that it must be a focus of the appeal. And it was incredibly difficult to let go of some of those feelings. And we did have those people work on the appeal, but we had somebody come in who didn't work on the trial, looked at it from a fresh perspective, and was extremely helpful. It helped us focus on the right arguments, summarize extremely complicated facts, and at the end win on appeal and reverse the trial verdict. So you see it, this isn't, the advice to get an appellate attorney isn't just for people who may not have experience in the appellate courts. It's really beneficial to the extent you have experience in both. One thing you have to think about on appeal is the standard of review. If it's an issue where the appellate court reviews it de novo, then your arguments might look very similar to what they look like at the trial court level. But if it's an issue in which deference is given to the trial court, you have to be very cognizant of that, and you have to lay out the standard and make sure that you argue to that standard throughout the brief. Now, last thing on this slide is the hierarchy of case law. Especially in state court, trial court decisions should be cited very rarely in appellate briefs. And that is definitely a difference you see a lot going to the appellate level. A trial court, it may be compelling to a trial court what his or her colleague in that same court did, but it is a lot less compelling to the appellate courts what happened at the trial level in other cases. Next slide, please. One section I often see copied and pasted is the facts section. And it's also the section that I find when I have a draft from somebody who doesn't do a lot of appellate work, that's the section that tends to need the most work. So I'm just going to go over some tips for the statement of facts. First, dates that are not relevant to the issues on appeal are extremely distracting. If you say the complaint was filed on January 21, 2015, that date should be relevant to something. If you're arguing about the statute of limitations or whether a party unreasonably delayed a case, dates are very important. But we see it all the time that a fact section is full of dates just because the attorneys are reciting the history, and again, it's, for a lot of people, it's just habit. Cite the record. The statement of facts must be true, and it must be accurate, and that may seem very intuitive, but if you're stretching the record or exaggerating what's in the record, You will lose credibility and it will undermine your case. Plus, what you risk, and what is virtually always happens when people try to do that, is that you will end up losing time at oral argument because the court will often ask you point blank about an assertion that appears not to be supported by the record. You don't want to lose credibility and you don't want to lose time at oral argument discussing whether or not you misrepresented something. It'll undermine this case and it potentially would undermine your future cases because credibility with the court is extremely important. Keep in mind that there will be cases when you're going in with weaker arguments on the merits, and everyone accepts that attorneys advocate for their clients even when their legal positions are not the strongest. But misrepresenting the record reflects very negatively and it affects you for a long time. The fact section, again, I think it's one of the most important sections. It's also one of the most difficult sections of the brief.
Lana, can I ask you, what advice do you have for counsel who is dealing with page limitations, but a very large record and a case that turns on an analysis or a synthesis of a lot of facts, where you can't really just drill down to the testimony of a couple of witnesses, for example? How do you handle that?
Sure. So if you have, and look, sometimes you do have a longer fact section because the facts are extremely important. Sometimes, courts do overturn, while it's rare, they do overturn on weight of the evidence. And anyways, you absolutely can have those situations. I think having subheadings is extremely helpful. It's also really helpful because when you have subheadings, you should put them in that table of contents that the court oftentimes reads first. And, you can use those to sort of frame the statement of facts. And the truth is, the court, when the facts are important, the judges will go to the record. So I think a lot of times when people see a big record, like we had a 15-volume record, and they almost disbelieve that anybody is going to actually go and look at it. But courts do. So, you can trust that when you cite to the record, if it's important, the clerks and the judges will go look at it. So I think that the hesitation a lot of times is just disbelief that somebody will go and, through these boxes. But judges absolutely do. And, the trickiest thing about the statement of facts, I believe, is that it shouldn't be argumentative. But at the same time, it is your opportunity to tell the story of the case from your perspective, from your client's perspective, and you can shape the narrative in that section. So, for example, you can't say in the statement of facts, the trial court inexplicably granted plaintiff's motion for summary judgment despite a clear triable issue of fact. I think that crosses the line and is too argumentative for a statement of facts. However, you could describe the trial court's decision in a way that gets the same message across. And you could say the trial court recognized and cited to appellate court decisions involving similar facts where courts held that a tribal issue of fact exists. Nevertheless, the trial court held that there was no question of fact in this case. Now, that's probably pretty close, the first sentence, to argumentative, but my point is that you can, it's hard and it takes a lot of time, but you can essentially argue without being argumentative in your statement of the case. Finally, you have to keep the fact section, and again, this is the tricky part, it has to be detailed enough for the court to get the facts it needs, but high level enough that it's not difficult to follow, and that nobody is discouraged from diving deeper into the case. And this is very difficult in certain fields. We handle a lot of energy-related work, and it is very challenging to frame statement of facts when you're discussing certain technologies, environmental programs, different electricity and capacity markets, things that a layperson doesn't necessarily know much about. So you have to give enough background but at the same time not get bogged down in the details, the technical details. You see it in medical malpractice appeals also, where there's an overuse of medical terms in the statement of facts. Again, you can't avoid them completely if it's a med mal case, but you also, can't make it so difficult to follow if people are tripping over the technical details. Next slide, please. Questions presented is, of course, a section that is not generally used at the trial level, but is required at the appellate level. And the general advice that I give is that your questions should track the points in the argument section. And usually, I actually usually draft the point headings at the same time as I draft the questions presented. If you have 3 questions, you should have 3 points. If you might have 1 question, but more arguments, then you would have 1 question, have 1 major point, but maybe have subheadings and sub-arguments. And ideally, you want the court to start agreeing with you early. And you also want to use the questions presented as your opportunity to argue. So on the next slide please. This is an example of a question that I think is a good one. And this is a real example. And if you read it, so it says whether the trial court erred in granting plaintiff's motion for summary judgment on the issue of liability where a defendant driver who rear-ended plaintiff's vehicle submitted an affidavit providing a valid non-negligent explanation for the collision. Now, even without reading the answer, hopefully the court reads that and says, wait a second, this just shouldn't seem right that somebody got summary judgment when there is a non-negligent explanation. And it should raise some questions right away. And then you can use the answer to explain a bit further and give a preview of your legal argument, that a rear-end accident creates a presumption of negligence, but it can be rebutted, and that's what defendant did here. Now, unfortunately, a lot of questions we see don't say much more than whether plaintiff's motion for summary judgment should have been granted. And then they say, answer the court below, yes. That really doesn't advance your case. It really doesn't help your case in any way. It essentially just takes up space and makes the court read further. Next slide. So this is another sample question, and this was a very straightforward case, and it was in Article 78. But the reason I wanted to include it is this is an example of how you should use the standard of review if it's friendly to you. So, so what we have here is the question is, did the planning board have a rational basis to reject a subdivision plan that essentially proposed that was proposed and would be contrary to the town code and the original subdivision plan? And the truth is, even without reading the other side's position, because the standard is rational basis, hopefully you have your audience agreeing with you from the beginning that, oh, yeah, these sound like rational reasons to go this way. And the standard isn't that they had to be right. The standard is that it had to be rational. Next slide, please. Now, the argument section, I don't plan to focus on it much, and I know we're running out of time. That's the section that should be most similar, except for which points you're actually arguing. So many times the argument section will look similar to what it looked like below. But some things to consider is, besides just saying that trial court was wrong or right, talk about why this is important. Talk about what precedent the court will set that perhaps will be really bad if the court doesn't go your way. and public policy implications. The further up you go, the more the courts care about, and the broader view that they take, as Judge Graffeo said. So I think there's just extra considerations for the argument section at the appellate level. And that's all I wanted to cover today.